Are we ready?
You're ready.
Well, unbelievable. We're starting on time. The first in, I hope, many starts on time. Last week, I wished you a happy Diwali, which is the Hindu festival of lights. And this week, I wish you a happy Thanksgiving, which was a celebration that we had with the Indians, excuse me, before we decided to eliminate them all. A sad chapter we won't go into today. There was an announcement made. I don't know what it is with my announcements, but we were going to talk about Obama, which would be wonderful, but we're not. We're going to talk about the Supreme Court, which is dear to Obama's heart and to mine. And we're going to talk about it through the collective careers of the major players, the justices, the Chief Justice and the many associate justices. And we're going to really concentrate on the period between the first great Chief Justice, which is a William and Mary alumni, and the current Chief Justice, who is, of course, John Roberts. The earlier man was from Virginia. He went to William and Mary. He and Marshall Wythe, together and a few other revolutionary leaders, to include Thomas Jefferson, were all graduates of William and Mary. And in his case, he served in the Revolutionary War, which is a major credential to get a job later in the soon-to-be city of Washington. You realize there has never been a Washington, D.C. before. But a Frenchman, always those French, they came and designed this little bit of territory that Virginia and Maryland gave to be the federal capital. So George Washington was not president in Washington, D.C., because there was no Washington, D.C. In fact, there was no White House. So Washington had to float between New York and Annapolis. And the first president and his wife to live in the White House was Adams. And poor Abigail had to hang her laundry in the upstairs areas because the ceilings in the attic leaked. So you have a leaky White House and an unhappy Abigail and an even unhappier Adams, because he is not going to win re-election, just like the current president did not win re-election. The difference between the two was that Adams admitted it and left office for that terrible Virginian from the other party known as Thomas Jefferson. So, but we're not going to waste our times with all these presidents and their comings and goings. We're going to talk about people all the way up to John Roberts. And we'll start with the first important president to deal with the Supreme Court. The first Chief Justice was actually John Jay. And he treated it as if it's an unimportant job. He was also governor of the state of New York, which made him very busy. And he was also negotiating treaties with Britain, the famous Jay Treaty. And in his spare time, if he had any, he would then look over to see if the court had anything to do, which was, in his opinion, no, it didn't. So you have two justices before the great man himself. And he comes on board having been around for a while. In fact, when he comes on board, he's first serving out the term of the Secretary of State. So he's acting Secretary of State and also a Justice of the Supreme Court. And then he becomes Chief Justice. And then he faces the first great challenge in American jurisprudence. That is, does the Supreme Court have the authority to declare what is constitutional and not constitutional as they see it? Now, the they were different groups of people at different times. The Constitution does not say how many justices there should be. It leaves it to the Congress. So initially, the Congress had only 6 justices. But during the 19th century, due to political pressures, it jumped all over the place. It went as high as 10. They were trying to block President Johnson, who was just about to be impeached. And then it went back to what you're used to now, which is 9. But it had been 6, 10, 9, all over the place, because the Constitution never set the number. They left it to the Congress to set. And the Congress was not sure of this odd body of lawyers who were going to tell them what they could and couldn't do. But finally, in a case that bubbled up by 1803, it hit the Supreme Court. It's Marbury versus Madison. Madison is, in this docket, the Secretary of State, and Marbury is a Marylander. He lives in Maryland, and he was due a judgeship. And unfortunately, it was not delivered in time. And so Adams, if he had been reelected, would have seen to it. It finally got delivered, but Adams was not elected, and Jefferson was, and Jefferson was from the other party. And so Jefferson declared that the undelivered judgeships, which were, by the way, being crammed down the throat of everybody because the Adams people wanted to make sure that they filled everything they could, and even more so, to block Mr. Jefferson and his ways and means. That's not unknown to be happening. In the last 4 years, the federal judges in the United States have been crammed down the throat of the Senate by the Senate Majority Leader. And so that you have a lot of Trump or Trumpers or whatever you want to call them acting as your federal judges, which is going to skew things for the next couple of years, perhaps, not necessarily, because there's a problem. These people get these jobs forever. It's a lifetime appointment, and so they can change their mind, and then you can't do anything about it unless you can impeach them. And you'd have to have a serious case against a sitting judge in order to impeach that person. And to impeach the many that we have appointed this last 4 years would truly be difficult. So President-elect Biden has a bumpy legal road ahead, but not so bumpy if he wins the 2 Senate seats, which are up for grabs in this coming January election in Georgia, of all places. But Georgia did vote for Biden. And many people are now going to Georgia or writing to people in Georgia, doing everything they can to make sure that the 2 Democrats who are running against the 2 Republicans, that the 2 Democrats win. And if they do, the Democrats will then own the Senate, which will really kill the guy from Kentucky. But those are not Supreme Court questions yet. They might be, given that everybody wants to sue today about any election that's held that doesn't go their way. Suddenly it's fake news, fake voters, fake elections. But when we had Marbury versus Madison, and when you have this wonderful guy from Virginia, who, by the way, was also born in another log cabins. There must have been log cabins all over this country in the 18th century. And this was a log cabin with only 2 rooms. And this soon-to-be Chief Justice was one of 15 kids in a 2-room. It's unbelievable, but it's true. They must have shared everything. And he must have wanted to get out of there in the worst way possible, to go on with a real life. Because if you're in a 2-room little shack with 15 brothers and sisters, you are in for lots of quarrels, troubles. But he went on, served in the American Revolution, and came out with a good reputation among people who were, like him, Federalist. Because you have to understand again that when the country came to be free of Britain, no longer 13 colonies, but 13 states, we had a great bias against the idea of parties. Parties in those days were called factions, and they were thought to be very negative. So we blithely thought we could have a country with no political parties. Well, we couldn't, because they started to fight and argue right away. The Federalists wanted a strong central government favorable to business. And the Republican Democrats, as they were called, wanted an agrarian policy favorable to people who work the earth. And so it was that you have arguments about high tariffs or low tariffs and all the other things that encumber government to do its work. So it was that by the time you're going to have the Supreme Court decisions, we already have parties. As much as we dislike the idea of doing that, when it came down to practical purposes, you needed to do it. And we did, with vigor, as John Kennedy would later say. So what are we going to do? We have this famous case, Marbury versus Madison. Madison being soon to be president, Madison being also Secretary of State, and a Federalist. And what had happened was Jefferson had won the election, which annoyed a lot of people. But people had gone into a very unhappy state over the Alien and Sedition Acts, and they turned against the Federalists and turned towards Jefferson's party. So Madison's people are quickly issuing a lot of federal judgeships, but they didn't all get delivered in time. You understand there's no email, there's no fast way to deliver a written document that seals the bargain between the federal government and you as a judge, a federal judge, and particularly a Supreme Court judge. And so Marbury didn't get his on time. And when Jefferson got into office, he stopped them from being delivered. So Marbury decided to sue. And so the case came by 1803 to the Supreme Court. And this gave the first of the great Supreme Court Chief Justices a chance to rule. Now, there have been 3 Supreme Court Chief Justices before our man, and they had only looked at 100 cases, not a very busy docket. And when the current Chief Justice took over for 30 years, he decided on over 1,000 cases. So suddenly it was a very busy judiciary at the top. And in those 1,000 cases, remembered most highly is Marbury versus Madison, because it enshrines the concept of judicial review, that in fact, it is the Supreme Court that can tell you whether or not the state courts and the state congresses or assemblies or whatever you want to call them can do what they do. For instance, the courts have ruled over and over again at this highest level that you cannot interfere with interstate commerce. Maryland cannot block trade coming from Pennsylvania down towards the Carolinas. It's restraint of trade. Interstate trade is guaranteed in the Constitution. And the Supreme Court is very happy to point that out. We had that case with Teddy Roosevelt, when in fact, there was a guy at Berkeley who wrote a book, the book called The Octopus. The Octopus was a novel, but it basically condemned the way the railroads were sort of gerrymandering the fees that they charged from state to state to state. So some were favored and some were not. And in the famous Hepburn Act, which Teddy Roosevelt pushed through, this was to cease. And it went all the way to the top, and the court said it is to cease. It's interference with interstate trade, and it cannot go on. So whether it's railroads or the building of turnpikes, as they were called in their day, all the things that happened between states were guaranteed to flow freely in the clause in the Constitution that deals with interstate trade. So over and over again, you constantly have, after Marbury versus Madison, the court ruling whether or not what was being done was constitutional or not. Let me give you a highly personal example. For some odd reason, the state of Connecticut, basically, since I'm a Roman Catholic, I can tell you this, the Roman Catholics began to dominate. And so they forbid the sale of contraceptives in the state of Connecticut. And this meant if you wanted to buy a condom, you'd have to cross a state line, buy it in Rhode Island or buy it in New York or buy it wherever and bring it back. And the court found this terribly perplexing and most unhelpful. And so they found it unconstitutional. Now, it depends on how maybe you feel about these issues, but the court takes them very seriously. And they brought up the subject of privacy, that people are, in fact, guaranteed their privacy. Now, the moment that happened, out of the darkness rose Scalia. Scalia by then was on the court, and Scalia, in a very famous decision, said, there is no right to privacy in the Constitution. And he's absolutely right. You can look and look and look, and you can't find it. But for those who have a broad interpretation of the Constitution, there is a right to privacy. Now, some people handle that in different ways. The French, for instance, the moment they find their Constitution slightly out of whack, they throw it out and they write a new one. They are now on their fifth Constitution. The Cinq République is writing on a Constitution that was written in recent times by Charles de Gaulle. And so it's referred to as the Fifth Republic with its fifth Constitution. We don't throw it out. We just take a broader and broader and broader interpretation, making sure we understand that the modern world keeps getting more modern and coming up with new questions that the court has to answer. And so there are many ways of dealing with this, but one is not to shut your eyes. But in the case of Scalia, there was no right to privacy. And he's a funny person, Scalia, because he was the friend, the opera-going friend of one of the most liberal people who ever sat on the court. And that liberal, of course, is Ruth Bader Ginsburg. But their connection was through Giuseppe Verdi and Puccini and Richard Wagner, and not through the Constitution of the United States, which they thought of in a different way, one broadly, one narrowly. And so it began at the very beginning, and it has continued to this very day. Presidents of all kinds have got troubles with the court. I'll give you a very famous case in your lifetime. Franklin Roosevelt was desperately trying to get this nation on its feet again, all during the 1930s. He came to office in 1933, and he lived through the entire Great Depression. He gave us big pieces of legislation, the National Recovery Act, the Agricultural Administration Act. Now, in both cases, those were found by the court to be unconstitutional. Suddenly, the court saw that the federal government was dealing in the marketplace in ways it had never done before, nor did it have a right to do so, according to the way they read the Constitution. They called the Agricultural Administration Act the Dead Chicken Act. And in the case of the National Recovery Act, they were determined to block this Roosevelt revolution. Now, to get that changed, Roosevelt had turned to his, he thought, good friend, Felix Frankfurter, who was then a law professor at Harvard. And he got him appointed to the Supreme Court. But little did FDR know that when it came to constitutional law, Felix Frankfurter was a strict constitutionalist. So he joined that group that said these things are unconstitutional. At that point, Franklin lost his temper. and decided what he would do is stuff the Supreme Court with enough justices that would then rule favorably in the way he wanted them to rule. Well, this was too obvious for everybody, and it got Roosevelt nowhere. In fact, we had a second, what's called the Roosevelt 1937 worst depression. It's like these cycles we're going through with COVID, when you have one and then you have another, and then you have another huge buildup, and then a drop off, and then another buildup. So now you have the Roosevelt depression, you have Frankfurter as a judge for life, and you have Roosevelt steaming in the White House. Now, of course, all of this is settled in a horrible way. The reason we got out of the Great Depression was because we followed the economic policies of John Maynard Keynes, which is to spend your way out. And John Maynard Keynes explained that to Franklin Roosevelt. Franklin Roosevelt said, well, I don't understand this man. And of course, Keynes said, Roosevelt has a first-rate, friendly disposition and knows nothing about economics. And so it is that by accident, we followed Keynes, but it was called World War II. By the way, if you didn't hear today, you have a new Secretary of the Treasury who will be broadly spending her way out of the pandemic. And her name is Janet Yellen, formerly of the Berkeley Econ Department, a very smart woman, and Biden's choice for that very difficult job. But all these things can always back to the court. What were we doing that was legal and what we were not doing? Now, John Marshall, that first great Supreme Court justice, made sure that everyone understood that if you came forward and you were challenged, the court would then hear the case, the Chief Justice deciding, oftentimes writing the opinion, and deciding on who will write the minority report, if there is to be one. Sometimes they're actually unanimous. And so it was that Marshall set his standard, and Roberts has continued to set a high standard in the court. But it's not always been easy. And the court has made some serious errors. Let me give you a couple of examples. In 1890, the court was challenged to look at a case, Plessy versus Ferguson. In the Plessy case, the question was, is segregation legal? And the real question was, is it separate but equal? And if it is, both of those, yes, it certainly is separate. African Americans went to school, as I did in Virginia in the 1950s, in segregated schools. There were black schools and then there were white schools, in the sense that white people went to one and black people went to the other. Now, when they listened in 1890 to the arguments that were being raised even that early, the Supreme Court decided that in this case, it was separate and it was equal, and so it is legal. Now, it was never equal. And it took an unusual set of circumstances. The fact that a Republican governor of the state of California had made a deal. He thought it was a hard deal. That is, he would bring the whole California delegation to the Republican convention that nominated, of course, Dwight David Eisenhower. He would bring it in for Eisenhower, betraying then Senator Taft, who was Mr. Republican. And this betrayal worked, and Eisenhower got the nomination, and Taft did not. And the quid pro quo, to use a word that's been recently famous, was that Warren would get the first Supreme Court position that opened up. And the first one happened to be the Chief Justice. Now, the Eisenhower people told Sacramento, we didn't mean Chief Justice, we meant the first justice. And the Warren people said, we mean the first opening. And rather than go public with this quarrel, Ike gave up and Warren became Chief Justice. And then we have the famous Warren Court. And it re-looked at Plessy versus Ferguson and said, it's not so. It is not separate. It does not become more, it's not equal. And so they overruled, which the court hates to do, to set aside an earlier interpretation of the court's law and put in a new, but they did. And so first, Plessy versus Ferguson was out, and the new Warren interpretation was in. Now, you only see this happening a couple of times, but most recently, and I'm sure to Chief Justice Roberts' disgust, another justice has decided that an earlier decision was also wrong. This justice is one of 6 Roman Catholic justices on the court. He's an Italian, Alito. And he decided to go public and say that the decision about gay marriage was a wrong turn and should be re-argued and thrown out. Now, he chose an odd time to do it because his own Pope, Pope Francis, in Rome had just declared that people involved in a gay relationship were also children of God, and they deserve the respect of being children of God, and he blessed their unions. This made the Trump administration very unhappy. It even made the Secretary of State make a statement while in Rome that was opposed to the Vatican statement, not that the Vatican gave a damn. And Pope Francis' view has become the view of the Roman Catholic Church. Now, you might think that doesn't matter, but it does. Let me go back in time. Officially, the Supreme Court, when it was nothing, and then when our friend over the Marbury decision made it very important, was made up really of white Protestant males, better known in the East as WASP. And only slowly did that change. Out of nowhere, Woodrow Wilson became the 8th Virginian to become president. And he decided to appoint the first Jewish justice to the Supreme Court, Brandeis. And Brandeis is very famous for many decisions like, quote, "It is not legal to yell fire in a crowded theater," end quote. Now, when he was nominated, it caused a stir, and it took over a year for the Senate to finally approve him, but he was approved, and he did sit in the Supreme Court. Now, this was a time when the Brandeis family, for instance, came to the United States. They came from Germany. He's a German Jew. There was no anti-Semitism to speak of within the United States. And the Brandeises left Germany basically in disgust because the Great Revolution of 1848 had gone against the liberal parties in Germany, in the German states, and that people even like Richard Wagner, who had been for the revolution, were now wanted by the police. And the German Jews who could get out decided to get out and come to the United States. When they came to the United States, they didn't settle in Brooklyn or just hang in New York. They went all over the country. The Brandeises went out all the way to the Mississippi River. So you have a very different world in the year the Brandeises come. And now you have a very different world. And when Woodrow Wilson reaches down and selects this unknown man to be a justice of the Supreme Court, and he went on to be a great justice for the Supreme Court. Today, we have, for instance, the first break, which comes for women, with, of all people, Ronald Reagan. It's Ronald Reagan who appoints the first woman to the Supreme Court. And in fact, it becomes so sensational when it's even rumored that it's going to happen, that a movie is about to come out and they postpone the movie until it is sure that this woman will sit. And she does. She is approved by the Senate. And the movie then flashes on the screens of America. It's called The First Monday in October. That's when the court first meets and then continues to meet all the way through May and sometimes June and sometimes all the way to July, depending on the docket. It's a very good movie, by the way. Walter Matthau plays a very, very liberal judge, and he's very unhappy that the woman who's coming on the court is in fact a very, very conservative judge. But they become friends, very much like Ginsburg and Scalia later in time. These people are not carved out of marble. They're living human beings. And their friendship extends to other things, having Thanksgiving in each other's home, going to the opera together, whatever. And so it was that you got a Jewish, you got a woman, and now you have 6, count them, 6 Catholics, many of them practicing. The last Catholic to go on the court is a woman who's just to prove her Catholic credentials. She has 6 children. It's almost as bad as the first Chief Justice of any fame at all, who came from a family of 11, and they weren't even Catholic, and they weren't even Irish. They just had a lot of kids. So the religious issues did stir the pot a little, with fear that in many areas of social justice, that the justice might rule according to their own religious views, which might not be the majority view. It would seem to me better that they just simply say, I stand aside on this issue and will not vote due to my religious convictions. Also, it might be interesting to find someone who is a Buddhist and put them on the court, or even, it would really shock the world, a Islamic person to go onto the court. There are a large number of Muslims in our country. There are a large number of Muslims here at Piedmont Garden. Why could they not have a famous lawyer, then judge, be finally made a justice of the Supreme Court? But you don't want to look around in such a way that you're trying to have a rainbow coalition. You're looking for the best person. And in many cases, we've had the best people. In many cases, we've not. In many cases, we've had terribly troubled presidents. I give you Lincoln. Lincoln had a war, the most deadly war we've ever fought. And without getting even the approval of Congress, he stopped the right of habeas corpus from being served. And even his Chief Justice at the time told him he couldn't do that. And his answer was, well, the court has ruled, let the court enforce. And Lincoln was wrong to do that. It is true that he was terribly worried about the issue of the war, the issues of slavery, the issue of rebuilding. Of course, most of that was cut short by his assassination and then the impeachment. which was not successful by one vote of his vice president, then to be president. So in all these many ways, the court gets entangled in these issues they don't want to necessarily be entangled in, but they are the issues of the day. You don't get appointed the Supreme Court to decide whether or not we should plant tulips around the White House or whether we should build another pretty item along the mall in Washington. We've prettied that mall up to the point you can't get another building on it. Most recently was, of course, the African American Museum, which is quite stunning, but has taken up the last bit of space that is there and is not my favorite. My favorite remains the Jefferson, and the next the Lincoln, and then the next the Franklin Roosevelt, the FDR, and then the next the World War II. But you might have your own. There are great museums like the National Museum, or as I call it, the Mellon, which is also on the mall, or the great Asian Museum, the Freer collection, which is also on the mall. And you can go on, the Hirshhorn, and of course, the great collection of scientific things that are on the mall in a building that was given to us by a British millionaire. Strange, those Brits, we revolted for them, and what do? They built us a museum 100 years later. But so the court continues to rule and has to work itself around. Now today, John Roberts does. Now I want to talk about Roberts for a moment. While Roberts was not on the court in his early career, but he was a judge, he sat down and wrote a rather famous, I think, unbelievably famous article in which he argues that this business of lifetime appointments is not good. Judges get old and cranky. Judges sort of lose touch with where the country is going. I think of all my friends here at Piedmont Gardens who are not interested in whether or not our governor had dinner at the French Laundry with too many people, and so he broke his own restrictions. It's just not the beginning and the end of their world here at Piedmont Gardens. And there are many other issues they're not involved in. And so what you want, says Chief Justice now, but not then, is term limits. 20 years. You usually don't get anywhere near the Supreme Court until you're in your 40s. And 20 years later, you'd be in your 60s, and in any other normal place, you'd retire. We even decided that at Berkeley. We had a university in which people just didn't want to retire. They wanted, and they were clogging up the hallways. They were too old to teach, but you couldn't, and so we put in a 70-year automatic retirement. And we had problems with that because the law does not allow you to have age discrimination, no matter how aged you might be. But the Chief Justice can today look elsewhere for people who know there are reasons to limit the time in office, even a very famous place in Rome, known to Italians as the Palazzo Vaticano, meaning the Vatican Palace. The popes have decided that the body that advises them, the College of Cardinals, is full of tottering, aging, old men. God forbid there be a woman. And so the Pope is asked, when you're asked by the Pope, that means do it, that you retire at 70. If you are a cardinal, a prince of the church, you will still hold your title, but you will not be allowed to vote for the new Pope, nor will you be able to serve any of the major offices that are in the papacy. You're just simply asked to retire, keep your title, keep your position, keep your stipend, but not help run something that belongs to the young. And so Roberts basically has made a very strong argument for, let's say, 20 years for federal judgeships and Supreme Court judgeships, and then you're out. And I think it's a refreshing view to look at the court that way and think of it as an institution that is and has to face the challenges of the new. What to do about this pandemic? Is there a legal question? How to get the vaccines to people justly and so that it is not done just for people in the Senate. Many of them are too old to care about, particularly the senior senators from South Carolina, Kentucky, my least favorite group. I can list more, but I think you get my drift. So the court will have to know something about the virus, how difficult it is to get the vaccine widely distributed, what groups should be selected fairly and first, and what will be the outcome of this terrible blow that's been given to all the people of the globe, how we shall share this vaccine with other people, people who can't afford it. The poorest of the earth's poor are not able to. I used India earlier in the Festival of Lights. India is suffering terribly from this COVID and has not the means or the ways to do what the United States and some European countries can do. But it is a humanitarian issue, and it should be shared as a humanitarian issue. And hopefully, if asked, the court will take it up if there's a challenge to the legality and will rule in a broad sense for the nature of this solution that would help in all those countries that need our help on a global level, as we would want to do if we were truly what we say we are. And so it is that Roberts is much challenged in his rules today. Now he has a justice who's gone off the reservation, so to speak, and talking about rethinking a issue that was put to bed. That is the issue of gay marriage. It's thought to be a settled issue that gay people may come together in a gay union that is thought of as legal. They may inherit property. They may visit each other when they are sick in hospital. They may do all the things that all couples in the United States can do. And it's a principle that's held widely in the civilized world. It's not just the United States. And now there is a justice who thinks we should rethink that and we should find that not to be legal and to disband these. I mean, if you want to see a revolution in the streets, I think you might remember the name Dan White, who murdered a sitting mayor. And then he was found not guilty by the flimsiest of excuses. Apparently he had had a Twinkie before he killed the mayor, Moscone, and this upset his metabolism so that he was not guilty of murder. Well, when that decision was made, the city hall in San Francisco was stormed by tens of thousands of people, mainly gays, but many other people who thought this was the most unjust decision they'd ever heard of. The Twinkie defense. All you had to do was have a Twinkie for lunch and then shoot somebody and then you were not guilty? Goodness me. And you'll have that again, because gay marriage is accepted now in the United States widely. You might not like it, but the system is. If you don't like gay marriage, don't have one. If you don't like gay marriage, don't go to one. If you don't like gay marriage and gay people, don't know anybody who's gay. Go your own way. It's just amazing. I want to tell you a little story. One, I got some corrections on my lecture last time. Number one, I didn't tell you the name of the great Broadway musical that had attracted so much attention because of the huge Puerto Rican airborne exodus to New York. And of course, that musical, and it's very famous, is West Side Story, with choreography by Jerry Ramos, by lyrics by Stephen Sondheim, by musical score, like Leonard Bernstein. An incredible array of talent put that show together, and it's one of the classic. It was also made into a film, nowhere near as good as the Broadway show, partially because Natalie Wood, as the lead, was nowhere near as Carol Lawrence, who was in the Broadway show. And the music of the show went viral. I mean, Johnny Mathis made a huge hit out of the love song Maria. So anyway, I forgot to tell you, and the name was West Side Story. I also forgot to tell you who William Randolph Hearst's girlfriend was. And I've written it down so that I don't forget it this time, because I'm good at forgetting things. And her name is Marion Davies, was the gal at San Simeon who frolicked in the pool and elsewhere with William Randolph Hearst, known to many movie people as Citizen Kane, which we will soon see here. We have a new system, apparently it's working, even has subtitles. So we will all be watching Orson Welles in one of his great moments in filmdom. So we don't want to get off track too far with this business of what the justices can do and what the court can do. It's a complicated system. It's worked well for us. It hasn't had many reversals. Occasionally it has unfortunate things. I'm probably going to be shot in the hallway after I say this, but Ruth Bader Ginsburg made a serious error when she heard, as a sitting judge, that Donald Trump had been nominated to be president of the United States, to run on the Republican ticket. She blasted away with both shotguns, saying he is not worthy to run for the office or to serve in the office. She really gave him a scathing denunciation. Well, I'm sure that she meant every word of her condemnation. But the point is, as a public official sitting on the Supreme Court, you have to keep those opinions to yourself. You can whisper them to your husband. You can whisper them at the opera too, hopefully during intermission, to your opera-going friend Scalia, who probably even agrees. But you may not tell it to the press, who can then tell it to the world. It's an unfortunate mistake, but everyone makes them. Right now, Alito is making it. He says we should rethink gay marriage. It was a mistake. Keep it to yourself. It's not to be debated publicly in the Times, the New York Times, as if it were a current issue. It's not a current issue. It's a settled issue. The court has ruled. Learn to live. The court might get involved in one more issue that they don't want to get involved in, and that is in fact Biden really the president of the United States? Or, in fact, was there a lot of illegal voting? Were there votes counted that shouldn't have been counted? Was this whole thing a gerrymandered thing that was set up to deprive Trump of a second term? Let us hope that John Roberts, as the current very excellent Chief Justice who wants term limits for his colleagues, that he will not take the case. And hopefully the lower courts in which the case is bubbling up will have already rejected it and not allow any further discussion in legal terms. But we will see. We are famous as a most legalistic society. We're always going to sue somebody for this, sue somebody for that. And so maybe, in fact, we will think it's necessary for us to go through the death knell of this Gadamarang president and his failure to recognize that even if he got some of the votes back, he will never get enough back to be president of the United States. He has L-O-S-T. He lost. He should now pack up and move back to New York, and good luck to New York City. But that will be up to the justices to decide. There are many who were appointed by Republicans, let's put it that way. That doesn't mean they support every Republican agenda, but Trump himself has put a couple of people on the court. And they, of course, are now serving under lifetime, and they don't have to do anything they don't want to do. They owe nobody nothing. But that will be for judicial review to decide. Hopefully, they'll decide to do nothing, that it isn't worth the paper any plea coming to them is written on. They will see, as others see, it's over, gone with the wind. But we'll have to wait for that moment when the packing trucks come. And if he doesn't move out, there is a group of people who don't like him at all. They're located in a strange 5-sided building across the Potomac River. And that's called the Pentagon, and they're called the military. And perhaps we'll have to see the indignity of his being moved out, and something that the court would likely not interfere with. Over is over, even in terms that the law understands. So it's been a long journey through these two very powerful chief justices, and they've had to put up with all kinds of people in between. In their own lifetime, Robert has seen Ginsburg come and Ginsburg go. He's seen Scalia come, Scalia go. Others saw Sandra Day O'Connor, the first woman. Others saw Brandeis, the first Jew. Others now look around them and find out they're surrounded by Catholics. One would hope that we had gotten over the religious wars of the 14th and 15th and 16th century, and that this idea of what religion you practice, or as most modern people say, I was brought up Catholic, which means not that they are practicing today, but they imbibed as children in the faith that is Roman Catholic. They were confirmed, as most Jewish kids were bar or bat mitzvahed. But then life went on. And certainly it went on if you went to law school. Certainly if you went to a law school like Bolt, which will always be Bolt to me. And even in places like that, let me give you an example of how it can fail. We were very lucky at Berkeley to get a woman as the head of the law school. She was very progressive. She tried to expand the base. She sent forward for confirmation by the Academic Senate a Korean American who wrote a number of pieces for the committee of the Academic Senate to review. Some of my friends sat on that committee. Their names will be locked away. But what didn't go forward, because it wasn't known at the time, was this Korean American had written for the President of the United States the famous torture memo, which authorized the use of torture in the case of some cases. The cases, of course, all involved in the 9/11 attack on the Twin Towers. And we did use torture. If we didn't use it on home ground, we used it on that base in Cuba that we had taken from the Cubans, Guantanamo, and if we didn't use it there, we sent these captured people to foreign countries where we knew the foreign country would torture them and get the information that we could operate with to capture those who had carried out this egregious attack on the United States. So it was that Wu became a professor in the law school. And then the word came out that he had written the torture memo. Lots of people were really unhappy that he was on the campus. Students at Bolt were unhappy. Our first female dean of the law school herself was unhappy, but it was too late, as seen by the way tenure is given. And so if you go to the law school today and take a course, you could take a course on Torture 101. That's obviously a bad joke because that's not offered. But the man who wrote for President Bush, Bush Jr., is in fact a tenured member of the Bolt Law faculty. Thanks to the first woman dean to ever be appointed to head Bolt. So no matter where you look in law, there's an up and a downside. And what to do about it is uncertain. Most people just want to wait it out. I guess you could say that Plessy versus Ferguson was waiting it out. It's 1890, and it's not until the 1950s the Warren Court rules that separate but equal is not equal and throws it out and brings in the end of segregation in all means. And the storm that followed as people tried to fight it, argue against it. Even my home state, to much of my shame, the state of Virginia decided to sell its public education system to private people so that as private people, they could then continue to run a segregated school system. How outrageous is that? To try and get around the law, something that Warren would have never allowed, and neither would Roberts. And neither was our first great man with his wonderful way of looking at law as an instrument for we, as he said in one of his most famous statements, quoting from a statement that Adams put in a court decision in Massachusetts. Quote, "We are a people of law, not of men." End quote. And the Supreme Court is that institution that tries to make that happen in a way that reaches everybody, not always reaching people who are here trying desperately to survive, like children on the Texas-Mexican border, who are taken away from their families, frightened, put in cages. This is something that I would expect only to happen in the Third Reich. Something that might have happened in a wonderful novel by a guy from Virginia who was writing about Sophie's Choice, where a woman, Jewish woman, is allowed to have a decision on what child she can keep and what goes to the death camp. But it happened on our border. We are responsible. And we will be held responsible because there are other courts above ours. The International Tribunal in The Hague, they try courts for violations of human dignity and have found in a number of cases that we therefore have refused to allow them to investigate fully our cruel and inhuman treatment of prisoners in Vietnam and elsewhere. But since we started on time, and we're now 2 minutes after the magic hour of 4, I'm going to cease belaboring the two great Johns who gave us a Supreme Court that is supremely good in most instances, with little quirks here and a little quirk there. And someday soon here, I will try and show the film, first Monday in October, which is that Walter Matthau film, with he, a liberal judge on the Supreme Court, and the woman, a conservative, and their clash as they come to make decisions. It's a very funny film, although much of the work of the Supreme Court is certainly far from funny. So until we meet again, and next time it will be on another issue totally. As you probably know, we were scheduled according to the famous never correct schedule to talk about Obama, and we have already mentioned him because we were, in my mind, scheduled to talk about the court. And next time, we are scheduled to talk about the 3 World War II conferences of Tehran, Yalta, and Potsdam. The conferences that set up the modern world that we live in today, with changes. It's been a long time since those conferences of the early 1940s. Thank you for listening today, and I'll see you next week.